India's legal system is among the most elaborate and heavily burdened in the world, built on a foundation of unchecked accumulation. The primary metrics show the scale of the bloat: 858 central acts currently in force, the vast majority of which operate without any built-in expiration or review dates. On this dashboard, those 858 acts sit alongside a judicial ratio of only 21 judges per million people. The resulting bottleneck has created a backlog of more than 5 crore pending court cases. While Parliament passes the parent acts, the majority of the day-to-day regulatory burden actually stems from subordinate legislation, rules and notifications written by the bureaucracy. The Environment Protection Act of 1986 illustrates this disparity. The parent act is only 15 pages long, yet it is buried under more than 1,000 pages of secondary notifications issued by departments. This functions as an open-loop system. It continuously intakes new regulations without a mechanism for garbage collection or the deletion of obsolete laws. The 2026 proposal outlines a move towards a closed-loop architecture, where the legal system is required to prune itself as a condition of its operation. The redesign begins by throttling the intake of new laws before they are formally drafted. Every new bill, excluding money bills, must now pass a mandatory regulatory impact assessment. This RIA must calculate the specific compliance costs for citizens and justify any new criminal provisions before the bill enters a 30-day public comment window. To prevent further volume growth, a one-in, one-out rule applies. For every new central act introduced, one existing act must be identified for repeal. This mechanical constraint forces a focus on the quality of legislation, as new laws can no longer be added to the pile without removing an equivalent burden. Current statutes rely on dense bureaucratic text that is often inaccessible to the citizens they govern. The 2026 proposal addresses this through a mandatory 2-tier drafting requirement for every bill. Drafters must produce a technical, legal version for the courts and a 5-page citizen version written in plain language. If a dispute arises from an ambiguity in the law, the citizen version is binding. A person cannot be penalized for following the plain language summary provided by the state. These filters ensure that new laws are only admitted if they have a quantified cost and can be clearly understood by the public. The next step is controlling the volume of rules and regulations that expand after a law is passed. Historically, departments have used subordinate legislation to bypass the scrutiny that accompanies a full Act of Parliament. The 2026 reform introduces hard page limits for all subordinate legislation, written directly into the Parent Act. Rules can no longer expand beyond a fixed geometric boundary. A mandatory 60-day layover period is also required, giving Parliament the opportunity to suspend rules before they take effect. Under the red card mechanism, any rule that carries criminal penalties or high compliance costs must be affirmatively approved by both houses of Parliament. To maintain clarity, all rules associated with an act must be consolidated into a single updated volume every 5 years. These caps ensure that the regulatory state remains within the specific boundaries set by the original legislation. These reforms are part of a shift toward legislative humility, the assumption that laws should be reviewed regularly rather than existing by default. The primary tool for this shift is a mandatory 10-year sunset clause for all new legislation. Under this timeline, a mandatory review is triggered at year 7. If the law isn't affirmatively renewed, it hits a termination wall at year 10. This creates automatic phase-outs for sector benefits and tax incentives, preventing them from becoming permanent features without rejustification. By setting these expiration dates, the system can autonomously identify and remove obsolete statutes from the active record. This pruning is managed through the AI-powered India Law platform, which uses smart contracts to track these legal life cycles. A new legislative expiry and review division monitors this data to track how laws are actually enforced across the country. Statutes that remain unenforced for 15 years are flagged as zombie laws and scheduled for automatic repeal. This structure creates a digital architecture where laws either demonstrate their necessity through review or are automatically cleared from the system. With the intake and pruning systems established, the final task is processing the inherited backlog of 5 crore pending cases. The physical strain on the courts is a direct result of the current ratio of 21 judges per million citizens. The proposal seeks to increase this capacity to 50 judges per million through the creation of an all-India judicial service. To increase case throughput, the reform imposes a hard cap of 3 adjournments per case and a 2-year limit for resolving civil matters. A major source of this litigation is jurisdictional overlap, particularly within the concurrent list. The 2026 proposal would sunset the concurrent list over a 10-year period, migrating every subject to either the union or state lists based on clear functional roles. Resolving the backlog requires both a massive expansion of judicial capacity and the elimination of the jurisdictional confusion that generates the cases. The total systemic impact of the 2026 proposal is designed to be measured over a 10-year horizon. The matrix of interventions covers every level of the legal process, from initial drafting to the final judicial resolution. These mechanisms treat the law as a managed life cycle, where every act is held accountable for its compliance costs and its clarity. The numerical targets are specific, reducing central acts to fewer than 500 and achieving a 70% reduction in pending court cases. Judicial density is set to reach 50 per million, with the average case resolution time falling to under 2 years. These targets rely on the mechanical enforcement of system constraints, rather than increases in individual effort or political will. By imposing these rules, the architecture shifts the citizen from being a subject of the legal system to being its primary user. Building a legal framework for 2047 requires a system that prioritizes clarity and speed over the preservation of historic complexity.